Welcome to the Deep Dive, your shortcut to being well-informed, fast. Today, we're getting into something really fascinating, the intersection between supporting small businesses and, well, the tough side of finance loan recovery. Yeah, our mission today is to unpack a pretty recent Supreme Court of India judgment. It's from July 28, 2025, and it clarifies this delicate dance, between laws protecting micro, small, and medium enterprises, MSMEs, and how banks actually get their money back when loans aren't paid.
Exactly. And this isn't just some dry legal analysis. It's really about understanding what this means on the ground for the businesses that need these lifelines and also for the banks trying to manage their risk.
Yeah.
It's about making sure these support systems, these frameworks actually, work the way they're supposed to.
Absolutely. And the core question, the thing the court was really wrestling with was this. Do banks have to, proactively look for incipient stress, those early warning signs in an MSME's loan account before they slap an NPA label on it, a non-performing asset? And just as crucial, what part does the MSME itself play? What's their responsibility here? Let's dig into this.
Okay.
So to really get it, we need to know who's involved. The main players were Sri Swami Samarth Construction and Finance Solution, that's the MSME, registered under the 2006 Act, and the bank, NKGSB Cooperative Bank Ltd. And the basic problem, like you often see, was pretty straightforward. The MSME took a loan, couldn't put it back. Simple as that, really. So the bank did what banks do. They classified the account as an NPA, a non-performing asset.
Right. And after that, the bank moved pretty quickly. On May 13th, 2024, they sent out a demand notice. This was under Section 13.2 of the SARFAESI Act that the Securitization Act will probably mention a few times. Gave the MSME 60 days, pay up. Well, that didn't happen. So the bank went to a magistrate using Section 14 of the same act. And that led to a court commissioner being appointed on April 3rd, 2025. The MSME got the official word on that appointment June 18th, 2025.
Okay, and here's where the timing gets interesting, shall we say. The MSME, they didn't argue about the NPA classification when it happened. They didn't object to that demand notice back in 2024.
No.
Instead, they waited. They only filed their writ petition with the Supreme Court on July 14th, 2025. That's, much later. The recovery process was already seriously underway.
Yeah, well underway. And the key thing they were relying on, the document at the heart of their argument, was this thing called the Framework for Revival and Rehabilitation of Micro, Small, and Medium Enterprises.
The framework, okay.
Exactly. It's a notification from back in May 2015 issued by the MSME ministry. This was supposed to be their lifeline.
So their lawyer, Mr. Nadumpara, he made a pretty bold argument. He said the bank should have spotted this incipient stress, the early trouble, before the NPA classification. He claimed this was basically mandatory for banks under that framework. And because the bank didn't do it, any action they took under SARFAESI was in excess of jurisdiction, basically illegal.
A strong claim.
Yeah. And he also added that the framework doesn't explicitly say the MSME has to tell the bank first, hey, look for incipient stress. He pointed to an older case, Pro-Nits v. Canara Bank, to back this all up.
Well, the court's reaction was pretty immediate and pretty clear. They said they were not persuaded to agree with any of the submissions advanced by the MSME's lawyer.
Okay. So a flat no?
Pretty much. They weren't buying it. And the legal principle they used to get there is called harmonious construction.
Harmonious construction. Okay, what does that mean in plain English?
Right. So imagine you have two laws. Like here we have the SARFAESI Act for loan recovery and this MSME Framework for support. Sometimes they might seem to pull in different directions.
Okay.
Harmonious construction just means the court tries to read them together, so both laws can work effectively. You don't want one law to completely wipe out the rights or purpose of the other. It's about finding, harmony, a balance.
Makes sense. Finding the balance.
Yeah.
So how did they apply that here? Because this is where it gets really interesting, right? They laid out duties for both sides.
Exactly. It wasn't just about the bank. They clarified things for the MSMEs, too.
Okay, so what did they say for the MSMEs?
Well, the framework itself says an MSME may choose to voluntarily initiate proceedings if it thinks its business might fail or it won't be able to pay its debts. Crucially, this is before losses get too big, like half its net worth.
So there's a window for the MSME to act proactively.
Precisely. But it requires a formal application verified by an affidavit, a sworn statement. You have to formally ask for this process.
Okay, and what about after things have gone a bit further? Like when the bank sends that SARFAESI demand notice?
Right. This was key. The court said, look, banks don't have to automatically hunt for incipient stress before the NPA or the notice. That's not their job initially.
Okay.
But if an MSME gets that Section 13.2 demand notice, that is the moment. The MSME must reply under Section 13.3a, state they're an MSME, claim the benefit of the framework, and back it up with an affidavit.
So the onus shifts to the MSME at that point. You have to raise your hand and say, hey, I'm an MSME. This framework applies.
You got it. You have to assert your rights then and there, formally.
Okay, and what about the bank's obligations then?
So, as I said, no duty to proactively find incipient stress before the notice. But, and this is the other side of the coin, if they do receive that proper claim from the MSME, the reply under 13.3a with the affidavit, then the bank is mandatorily bound. They have to look into that claim. And importantly, they have to pause further SARFAESI action while they investigate.
Pause SARFAESI. Okay, that's significant.
Very. And if the bank finds the claim is valid, then they must follow the procedures laid out in the framework for trying to revive and rehabilitate the MSME.
So the framework does kick in, but only if the MSME triggers it correctly after the demand notice.
That's the essence of it. Which brings us back to the specific case. The court pointed out that this particular MSME apparently never did claim the benefit of the framework after getting the demand notice.
They missed their chance, according to the court.
Seems so. The court even said the timing of their writ petition, coming so late in the game, made their bona fide suspect. They questioned whether the MSME was acting in good faith.
Because they waited until the court commissioner was appointed, right when things were getting serious under SARFAESI.
Exactly. It looked like a last-ditch attempt to stall things.
Okay, let's quickly touch on that pro-NITS case the MSME mentioned. That case did say the framework binds the banks, didn't it?
It did. Pro-NITS was important for establishing that the framework wasn't just, some vague guideline. It had teeth. Banks had to take it seriously.
So how does this new judgment fit with pro-NITS? Does it contradict it?
Not contradict, but clarify. It adds a crucial layer. This judgment highlighted that pro-NITS didn't just talk about the bank's duties, it also stressed the MSME's obligations. It quoted pro-NITS saying, MSMEs need to be vigilant enough to follow the process and provide authenticated and verifiable documents to show they're eligible for the framework.
So pro-NITS already hinted that MSMEs need to be proactive.
Yes, but this new ruling really spells it out. The court said pro-NITS kind of left unsaid something, which is that an MSME can't just sit back and then try to misuse the process of law by suddenly claiming MSME status very late, especially if they've already tried and failed to challenge the bank's actions earlier.
Right. You can't use it as a get-out-of-jail-free card at the 11th hour.
Precisely. So the bottom line for Sri Swami Samarth Construction, their writ petition was dismissed. The Supreme Court saw no reason to step in, no merit in their arguments given the circumstances.
Okay, so let's boil this down. What are the big takeaways here? For MSMEs listening, what's the key message?
The absolute key message is timing is everything. You cannot be passive. If you believe you qualify for help under the framework, you have to act fast. Specifically, that means responding to the bank's Section 13.2 demand notice by filing your claim under Section 13.3a with the proper affidavit.
Don't wait.
Don't wait. Waiting until the bank is already moving ahead with enforcement, like appointing a commissioner, that's likely too late, and the court might think you're just trying to delay things unfairly.
And for the banks, what's the takeaway for them?
For banks, it confirms they don't need to be mind readers. They don't have to preemptively diagnose incipient stress before issuing an NTA or a notice. However, once an MSME does correctly raise its hand, provides the documentation, claims the framework benefit.
Now they have to hit pause.
They have to hit pause on SARFAESI and seriously engage with the framework process. It's about respecting that process once it's properly triggered.
So it really comes down to this idea of reciprocal obligations, doesn't it? Both sides have a part to play.
Absolutely. The framework is a potentially powerful tool for helping struggling MSMEs, but it needs active participation. It's not automatic.
So there we have it. A really neat example of the Supreme Court trying to make two important laws work together, supporting small businesses while also allowing banks a clear path for recovery when necessary. It's not about one trumping the other.
No, it's about harmony, like the court said. And it really underscores that these protection frameworks, they only work if the people they're meant to protect know about them and use them at the right time. Proactive engagement is key.
And for you, our listener, maybe running a business or working in finance, It's just such a clear reminder that understanding the procedures, the deadlines, the steps you need to take, it's absolutely critical. Acting decisively makes all the difference. Which leaves us with a final thought to chew on. Could this ruling, this emphasis on the MSME needing to act early and formally, actually encourage a shift? Maybe push businesses and banks towards talking sooner, spotting those early warning signs together, more collaboratively before it gets to the stage of formal notices and legal battles. What do you think?